Again, my name is Joel Krooks, and I'm an attorney here at Littman Krooks, and welcome to Lunch and Learn with Littman Krooks. Today, we're going to be talking about the pitfalls of a do-it-yourself will. So this is like a legal Zoom where there's many different companies that do it, but that's just one example. So I actually went through a do-it-yourself will myself just to see what it's like, what questions they ask, how it's given to you, and how they expect you to sign it. So I went through the process myself, and I determined a few pitfalls that I saw as big problems for people who do their wills themselves and don't contact an attorney. So the first thing is I did a will with no guidance. So I didn't have, you do have options of getting an attorney to talk to you. I'm not sure about the experience of the attorney or if they're capable of practicing in New York where we are, but I just did the will on my own. And throughout the process, I was not informed of the consequences of what I was picking through the questionnaire process. So I was able to give money to basically anyone I wanted to outright. And this can be a big problem. Say you have a child with a disability, or say you give money to a minor. There's numerous issues that can result if people can just go willy-nilly and just give money to whoever they wanted. That's why it's very important to contact an attorney who can advise you on if this request is proper and if this distribution is made correctly. A prime example of this is if you have a son or a daughter or even a spouse with a disability. It's very important that their request goes into a supplemental needs trust for their benefit in order to keep Medicaid or Social Security or any government benefits that they're receiving. Another person who you don't want to give money to is a minor child, because this can, outright, so if that means not putting it into trust for their benefit. This can cause the court to get involved when you pass away if they're still a minor, and this can lead to numerous issues including the court getting involved in appointing a guardian for estate administration fees that would result in very high estate administration fees. Another issue is you can leave no money to your spouse. So I was able to choose not to give any money to my spouse, and that can, in New York, your spouse has the right to 1/3 of your property or $50,000, the greater of the two. So this can lead to your spouse contesting your will because they weren't bequeathed anything in it. In addition, a common misconception is that people's wills control all of their property. So they can control every piece of property, assets that they have. It's a common misconception, and actually the will only controls assets that don't pass by operation of law or through a trust. So for example, if there's an account with a beneficiary designation on it, or if there's a joint account, or your account is in a trust, your will not control this. So in order to accurately have your wishes portrayed in the will or in your estate planning, you want to make sure that you know whether your accounts have beneficiary designations, whether they're jointly held, and know whether the will is controlling these assets. Then another potential pitfall is, say you don't have a spouse, or say you don't have children. This can lead to a very expensive estate administration proceeding if you don't have a family tree with your will, or you don't, because the court has to notice certain parties in your who are your closest relatives. Now, this would not be possible. It's very difficult to do that sometimes if your executor doesn't know your family tree and who your closest relatives are. So usually it's easy if you have a spouse or you have kids, that's very simple. But say you have say your closest relative is a sibling. It might be best to do a revocable trust in the situation in order to avoid the probate process. And this was never mentioned to me throughout the entire online do-it-yourself will process. Another pitfall that I found is that they never asked me what my assets were. So they never asked me how much I have in assets, which is an experienced estate attorney would always ask you how much money you have and where you have it, and if you own a house or whatnot. Because if you own a certain amount, if you're very wealthy, for example, you might have, there's certain trusts that you can do that will be beneficial for your tax reasons, and it could prevent your estate from paying a very large estate tax. It's also, if your estate is very minimal, you don't want to leave a giant specific bequest to someone. So say your estate is only $50,000, but you leave a $100,000 bequest, and then the residual estate was supposed to go to your children. That would leave, actually, your children would get nothing in that case, and only the $50,000 bequest would be paid. So it's very important for a drafting attorney to know your assets and to know how much money you have and how much money you will have at your passing. Another pitfall that I found is that there was no, they never asked if I had a blended family. So they didn't ask if there was any stepchildren. They didn't ask if there was any, if I was ever divorced or any type like that. So stepchildren actually have no rights to your will. So the only way in your will to your estate. So a stepchild would not be entitled to anything unless you specifically left them property. So therefore they can't, if you were close with your stepchild and wanted to leave them certain bequests, say like $20,000 or something, to make sure that they're comfortable, you would have to do this in your will, or else they wouldn't get anything. So I was very, I guess, shocked that they didn't ask that question. Now, the biggest issue with these online wills is that from a litigation standpoint, it's actually a litigator's dream to have, to see one of these online wills if there's a will contest. Now, there's just so many holes that they can poke in the actual execution of the will. And this is probably the biggest pitfall of the will itself. So if the will is ever contested, who can speak to what your intent of your wishes were? Usually when you go to a drafting attorney, so say you come to me and you ask me whether, and you tell me your intentions, so that you wanted to leave money to your spouse or your children or a distant cousin, or you want to disinherit this certain child. The only way I would know then, and I could testify that this were your intentions. I don't think a computer system is going to be able to do that for you, or that a court would take what that intention was. So it's very important for you, if you have a will that might be contested, for you to have an attorney, because the attorney can actually testify to your intent. In addition to that, if there's any undue influence, how would you know? How did the program know that I was the one filling out all of the information in the signing? It could have been anyone acting as me. So nobody knew that I was filling out the questionnaire with my information. Someone could have just put Joel Krooks and then filled out a bunch of other information, like that I wanted to give $100,000 to Derek Jeter, per se. There's just, you never know, unless they're talking to an attorney, you don't know what their wishes are. So undue influence is a big problem, and say a health aide who's working with a person might draft this will for them using one of these websites, and that can be a big problem. Now, of course, still the person has to sign the will, but they could bring in a few witnesses and a notary and have them sign it. So there's just, there's just a lot of issues that can arise with undue influence in these types of situations. Another potential litigation issue is capacity. Who's determining who has the capacity to do these, for you to draft your will and sign it? So you might not have capacity to sign your will, but somebody might, another example, a home health aide might still try to get you to sign it just so that they get money from you. So they might put a bequest in the will that you would get, or that they would get $100,000 or all of your estate. And if they're the ones witnessing your will, or if a few other people are witnessing your will who they're friends with, and one of them's a notary, then that could also lead to an issue if you didn't have capacity. So I was provided instructions on how to sign the will, but that doesn't mean that I understood them or knew how to do it correctly. So in New York, 2 people have to witness your will, And those have to be uninterested. So it can't be someone that you bequeath property to or someone who has a right in your estate. So if you would come into a law firm, we have many uninterested witnesses here. We have a lot of people who work here, and they can come and witness. We do this all the time, where they come and witness people's wills. So we know the witnesses, and so if there was ever a contest also, we can find where the witnesses were. We always take a note on who the witnesses of the will were. So in case there was a litigation, we could call these witnesses to testify that the person was of sound mind. This were his wishes. He understood the document, and that this is what he wanted to sign. Again, another thing that I was, I guess, shocked about was that in the instructions, they didn't tell me that I should never unstaple my will. When the surrogate's court receives a will that's unstapled, sometimes they might say that this will is invalid. We, as attorneys, have to draft affidavits saying that this was the will and that nothing was changed or entered into it. Because if it's unstapled, who's to say that someone didn't switch out the pages? So if page 2 was substituted for a different page 2 that looked just like this, what the person intended page 2 to look like, but it was unstapled and it looked like it was, I guess, disturbed with, and that could be a big issue as well. So whenever you do one of these, if you do one of these wills, which I don't recommend, you need to staple it and make sure that it never becomes unstapled. At Littman Krooks, we have a peace of mind program, and we actually keep a lot of wills in our vault, and so we never touch the wills once they are signed, and we keep them in our vault stapled, and so they don't get wrinkled or they don't get unstapled. And so when we're ready, when someone passed away, we're ready with the will, and we know that it's valid because we were the ones who executed it, and we know that it's not unstapled. So in addition, we would know if there was any possible contest because we're familiar with the situation. So those were just a few of the main pitfalls that I found. The biggest, obviously, are the litigation issues that may arise from a will that's on do-it-yourself will. I've actually never seen, in my experience, I have seen very few of these wills actually get admitted to probate successfully. So it's extremely important that if you do want to draft a will, that you contact your attorney and have the attorney draft the will for you, execute it for you. Actually, right now, we can even do remote executions because of COVID. So if you can't get out because of everything that's going on with the pandemic, we can still execute a will for you. And another pitfall that I found is that a lot of people don't understand the terms that the questionnaire was asking. So I'm very familiar with the terms testamentary trust, credit shelter trust, marital trust, all these different types of trust, executor, trustee, because I do this on a daily basis. But not everyone or a layperson wouldn't do this on a daily basis, and this might all be new to them. So we at Littman Krooks explain everything to them, and if they have any questions, we have a whole meeting just for going over any questions you have regarding your estate planning drafts. This never occurred, obviously, when I was filling out the questionnaire. And if I wanted to research any of these terms, I would have had to Google them. And what you can find on Google varies. And so you might find a term like testamentary trust, and you might think this is just as good as a supplemental needs trust, when that is not the case at all. So it's very important that people understand the terms in their will and what the actual distributions of and what the actual paragraphs in the will is saying. I found that this was a big problem. I actually had my fiance do it because she's a layperson who doesn't do this often. And one thing that she did that she made me trustee of someone else's trust, but I would have already been passed away if that person were to receive a bequest. So it wouldn't have lined up accurately, and I actually wouldn't have been able to get trustee of, for example, a kid's trust because I would have been already deceased, and that's because that's the only way that the kid would have received money under this will. So it's a little tricky, and it's almost a puzzle sometimes of making sure that everything is in order, and that's why you need an estate attorney to draft the will for you and to make sure that everything's in order. The trustee of any trust that you have under your will is a very important person in your estate plan. And if that person actually can't act and you didn't nominate a successor trustee, then you're just going to have a lot more issues. So the online will process might save you money now because it's a lot cheaper than an attorney, but in the future or in your estate administration process, it's going to cost you a lot more expenses than it would have if you would just have gone through the normal probate process and seen an attorney. So you might think you're saving money now, but you're actually costing your estate a lot more money in the future, and your kids or whoever you bequeathed your or spouse, whoever you bequeathed certain property to, might actually lose out on more money because of the fees associated with your estate administration. So I can't suggest enough the importance of actually going to an attorney for the online wills, to draft a will. There's just so many issues that can arise if you don't go to an attorney, as some of them, as I outlined many of them here. They didn't just, you can leave money to anyone you want. So if you're a child with a disability, a minor, you can not leave money to your spouse, or you might leave money to a random person, like a celebrity that money's never it's gonna be difficult to get to that celebrity. They never discussed your assets. They didn't discuss whether you're in a blended family, whether you have stepchildren, whether you have children from a second marriage. So there's just so many aspects that were never discussed with me, or I couldn't read about on the do-it-yourself portal, that I would highly suggest going to an attorney for, because everybody's situation is different and complicated, and you might think your situation's very simple and straightforward, but then you meet with an attorney and you realize that there's a lot of things that you didn't think about. And there's a lot of contingency plans that you didn't think about. So you might have wanted to leave money to your spouse, but what happens if he predeceases you? And so a lot of people don't think about the next generation, or what happens if this occurs. So there's a lot of contingency plans in place that also need to occur in a will that you might not think about if you don't do it every day. So if anyone has any questions, I'm happy to discuss to answer them. You can just post it in the chat. But otherwise, I think I've explained that it's very dangerous and very risky to do it yourself will, and it can lead to numerous litigation issues and your wishes not being carried out the way that you want. So we at Littman Krooks are here to help you through the process, and we can guide you with how you want your estate to be distributed, and how you would like everything to go when you pass away. We would make it a lot smoother than it would be on a do-it-yourself will. So I don't see any questions at the moment, but I'll wait a little bit to see if anyone thinks of any while I'm here. So again, I'll just say how important it is to go to an attorney to have your will drafted. We're doing it every day. If someone asked if there's an instance where do-it-yourself is okay, I would say I would never recommend you do it yourself for all the reasons. Even if it's a simple, you're giving the money, you're giving your estate to your spouse, and you have like 2 kids, I still wouldn't recommend it. Because of all the issues just with signing it and making sure it's validly executed. Because if it's not validly executed, the will be invalid, and then it would pass intestate. So as you didn't have a will. If an interested person is a witness to a will, then that could also lead to numerous issues. If it could lead to it not getting accepted into probate and not being a valid will. So a person may think they have this will all set and everything complete, but then they find out that a will was that there was an interested witness, and the court may say, no, this will is not valid and it's therefore revoked, because there could be undue influence. Does probate also always needed in additional to the will? So probate, even if you have a will, it doesn't mean that probate is needed if nothing passes through the will. So it's possible that your estate is passed through beneficiary designations, or everything is jointly held. Then probate would not be involved, and you wouldn't need a will. Or you still need a will, but nothing would pass through the will. Because the will is like a catch-all. If, say, you have beneficiary designations or a joint account, and you think everything's taken care of, but then you find something that wasn't, that's why a will is so important, because you might miss something. There's in New York State, there's something called unclaimed funds, and this is something that's very, you Google unclaimed funds New York, and you can put in your name, and you might have something that's people have been trying to get to you, but they haven't been able to. And everyone here should search their own name and find out if they have anything. Sometimes they just send you checks if there's someone's been trying to reach you. So I don't see any additional questions. So thank you everyone for joining us. And if you have any questions, you can email us, and I look forward to hopefully working with some of you on your wills. So thank you.